with judgments of the High Court, and mainly it is judgments which are covering into the ITR volume 455, and part 2 is there. And in this judgment, in this series here, we have something very important to cover. Very, very much important discussion to be covered, because when one of the judgment, that is the 455 ITR 211, which talks about the Sanjay Gandhi Trust, Sanjay Gandhi Memorial Trust. The matter is pending before the Supreme Court, and Supreme Court has to hear this matter in the month of August here. So we will go through each of the discussion. The first case law, first case law will take much more time here. And after that, there are 2 Supreme Court judgment also into this part here. We will be covering on that part here. So let us start with the first judgment, which is about the Sanjay Gandhi Memorial Trust, which is from the Delhi High Court, and it was argued by Arvind Thakur from the SSC side here, and Tushar Mehta from the. So Naman, can you go to the Naman? Naman?
Yes, sir. ITR
Yes.
number. Yes, sir.
Yeah, ITR number 455-164.
Yes, just a minute, sir.
संजय गांधी है ना पहले.
हाँ जी.
This is a long judgment here. We will go through the bit slow here, because there are a lot of legal part are also covered here. Yes. Can you make it full size here? Because full screen here. Yes. The issue in this case is that there are few of the organization, and for their organization, the assessment or the reassessment process has started. However, once the assessment has been started, the department, in exercise of the power under section 127, has transferred the case to the Central Circle, Delhi, and from the Central Circle, Delhi, the first petition is that under the faceless assessment scheme, or under the assessment scheme, the section 127 has to be read down. Why the section 127 has to be read down? Because once the assessment scheme and national faceless assessment scheme has started, there is a commissioner faceless, commissioner NFAC, and once the commissioner NFAC has there, therefore there is no case of the judicial assessment officer, and under that situation, the section 127 has to be read down. This means first contention is that after the scheme which has been notified under section 143(3)(a) and 3(b), that is called the faceless assessment scheme, there is no jurisdiction. There is no concurrent jurisdiction, and once there is no 127 has to be read down here. This is the first contention in that. So We will go through this part here, 127. The second point is that if there is a 127 has been exercised, this case cannot go to the central circle because the central circle is mainly for the purpose of the search and seizure matters here. The department has also said that what is the meaning of the central circle, when they can transfer the case to the central circle, whether it is confined with the search and seizure matter or any other matter can also go to the search and seizure matters here. And this will go through the various notification which has been issued by the CBDT and various provisions of the section 143, 143A, 143B, section 127, or section 120 of the which talks about the jurisdictional assessing officer, and most important, the term which is very much important to understand, the concurrent jurisdiction of the assessing officer means one is the National Faceless Assessment Center and one is the Jurisdictional Assessment Officer, JAO, JAO. So what is the correlation between the two? How the two act? What is the division of the work between the two? Whether both can exist or under which situation, what is the both can exist? If the both can exist, can we say that it is the concurrent jurisdiction, or how to interpret the section 120 the e-assessment scheme or the National Faceless Assessment scheme, which was through the notification which was issued under section 143(3)A and 143(3)B, and which subsequently has came under the statute through the 144 here. We will see that part here. Let's go to the section here. We will go into the fact here. Coming to the fact, especially come to the fact here, para number 1. The fact is it is a writ here, so we will definitely go on the legal point, and then we will definitely jump on the legal issues which are there. Yes, please go to the para number 1. Yes. Down the line. Yes. Primary issue that arises for the consideration in the present batch of writ petition is whether the assessment of the petitioner could be transferred to the central circle by way of impugned order passed under section 127 of the Income Tax Act without sanction of the CBDT. So this was the main contention of all the batch of all the petitioner here. And if we come to the para number 2 onwards, we will a bit understand what is the issue in between here. The issue is by between here, and we will discuss the argument which is there. In the para number 2, it talks about it is pertinent to mention that the present batch of writ petition has been preferred by the 5 charitable trust, Sanjay Gandhi Memorial Trust, blah blah blah. And in the para number 3, it talks about the present writ petition. The petitioner have challenged the transfer order passed under section 127, whereby the jurisdiction of the petition has been transferred from the exemption circle to the central circle, or in the case of Aam Aadmi Party from the exemption circle to the Deputy Commissioner Income Tax Central Circle, all the income tax, both transfer and transferee are located within the transfer assessing officer and the transferee assessing officer are sitting within the same locality here, even though they may be under the different principal commissioner here. So there is no change of the city is not there. So we will see that what is the scope of the 127, how to discuss about the 127, what are the power under the 127, whether 127 is a totally administrative order or 127 can be said that it is a quasi-judicial order here, because the moment it is the administrative order, we will see that whether the scope of the right to be audi altrum should be there or not there, whether the natural justice, whether the notice should be issued to the AO or SSC or not here, whether the SSC can represent or can object into this case or not here, because it is a purely administrative order here. Second part is that where there is a quasi-judicial order here, where the law of natural justice will come into the play. So we have to understand the difference between the administrative proceedings and the quasi-judicial proceeding here. We know that under the Income Tax Act, there are certain processes are there which is purely administrative process. You cannot have the right to represent there, or you cannot file any objection for this purpose. Certain processes are the quasi-judicial proceedings here, where you can get the you have to follow the rule of law, and the rule of law will include the natural justice and audi altrum patent here. So this is the under such exercise, or whether the 127 has been read down into the in the context of the national face assessment or in the context of the e-assessment scheme here. Coming to the now the argument starts here. Argument is there from the 4.1 here. Yes, 4.1. The 4.1, particularly the Sanjay Gandhi, is the lead case here. The Sanjay Gandhi Trust was established with the intent of providing health service, education, employment of the people of the rural Uttar Pradesh. The trust manages rural medical center, Sanjay Gandhi Hospital, education institutions such as Indira Gandhi School and College of Nursing, in Indira Gandhi Institute and Paramedical Science, Indira Gandhi Technical. The petitioner is registered as a charitable institution under 12A, and the assessment has been completed under section 143(3). And after that, the proceeding has been, and that there was no issue of the dismissal. And now come to the legal development here, which is coming from the Finance Act 2018. We know that before Finance Act 2018, there was a physical assessment was taking place. Everything changed from the 2018. And let's see how the 2018 has come with the transformational change in from the assessment scheme. Earlier, it was a physical. We have to go to the department. We have to sit before the AO, explain the issue. There was a lot of, you can say that malpractice was going on, and with the e-assessment scheme. So 4.3 is the very much critical paragraph, which talks about the concept of the e-assessment was introduced by subsection 3A, 3B, and 3C under 143. 143, and the central government was delegated with the power to modify the scheme conducting the e-assessment scheme 3A, 3B, 3C under the 143. And subsequently, it is the 3A, 3B, 3C is there in the next para. Can we go to the next para? Naman, can we go to the next 4.4? 3A, 3B, 3C is there under the, we will go through the complete part here. And in the year 2019 itself here, Para number 4.4, the e-assessment scheme was notified and implemented through the central government by two notification. This notification is the bone of contention before the court here. That was notification number 61 and notification number 62, which is there here. What is the notification number 61 is there? 61 talks about the e-assessment scheme. Under the e-assessment scheme, there's a different scheme which can we go down here? What is the complete formality of the e-assessment scheme? And in the e-assessment scheme, there is a procedure for assessment has been given here. Can we go to this part here?
So I've opened the
Yes,
notification.
can you just make it this one here? I'm not able to see the full view. Go through the full view here. Section 143, 3A, 3B, and 3C. And this is the notification number. I feel it is the notification number of the 12th September 1919. That was the notification number 61. And subsequently, the 62 number was also issued, which talks about the what is the e-assessment scheme here. And we know that what is the e-assessment scheme, National E-Assessment Center, regional e-assessment here under the verification unit and the procedure of the assessment and the national e-assessment business. Subsequently, there is another notification. Notification number 62 is there. 62 number notification is there, and notification number 62 talks about the what are the law that will apply into this part here, and which are the section, whether the 26 section 127 will apply or not apply. These are the 127 will go there. And after this, under the 120, the assessments will be made in the following chapter. And subsequently, yes, this is the notification number 62 was there, and 62, and after the subsequently, there was an amendment in the statute here, and the notification number 60 of the 2020 and 60 of the 2020, where the National Faces Assessment Center was brought here, and 61 of the 2020. So there are four notifications: 61 of 2020, 61 of 2019, 62 of 2019, 60 of 2020, and 61 of 2020. These are built broadly. There are four notifications which is covered under that part here. Can we come to the para 4.10 here? Keep on the this one, sir. Don't change the slide here. Yeah, please. Para 4.10. Yeah. Yes. Four 4.10 talks about that how the National Faces Center and the Faces scheme was there. We are directly coming to the para 5, and here after this broad scheme, there's an argument which start from Arvind Dhatar. And what is the argument here? Just go through the para 5 here. Para 5. Yes. What is the first argument which takes place? With Arvind Dhatar, learned senior counsel, appearing for Sonia Gandhi, Rahul Gandhi and Priyanka Gandhi. It talks about they start from the budget scheme of 2019, and again going to the budget scheme, they are invoking the e-assessment scheme. What was the purpose of the e-assessment scheme? And after that, in the para number 6, he talks about the faceless appeal was introduced in the line of the faceless assessment, and all this scheme was discussed. In the para number 7, highlighted the intention of the central government, that what should be the central government should, why the scheme of the e-assessment has come. Can we come to the para number 7? Yes, it talks about the purpose of that. According to him, the aforesaid highlighted the intention of the central government to eliminate personal interaction in a faceless assessment and appeal, which is now the new method of assessing income tax cases and deciding appeal. He emphasized that the assessment have to be processed only on the basis of written submission in electronic mode. Thus, the existing assessment of a person in Jaipur will no longer be carried out by the judicial assessment officer, subject income tax officer at Jaipur, but the assessment will be completed by the NFAC. So he's talking about the purpose of the national faceless assessment scheme was to eliminate the personal interaction between the assessing officer and the SSC here. And after that, he has discussed about the various para of the scheme here and why, how to be going through this para here. And
PCR investment version 1899.
And come to the para number 9. From 9, the argument starts there. Let's see what is the para number 9, which the argument. These are the brief statutory law, what is the statute, and first argument it says that
2020. Okay.
he stated that all the assessment will now to be conducted through the faceless assessment center. Once all the assessment should be through the faceless assessment center, there is no scope of the manual assessment. There is no scope of the interaction with the AO, with the SSC here. Therefore, transfer to the central circle, where the assessment takes place on the basis of the manual interaction here, without any faceless assessment. He started the argument saying that the SSC has a vested right. Now he is saying that SSC has a right to go for the national faceless assessment. Once the right is there, unless there is a carve out, like the carve out is for the purpose of international transaction and search matters. Since the SSC case is not falling under the international transactions and the search matters, therefore it cannot be forced to go for the central circuit here. So first argument he talks about, he started the review of the aforesaid. He started that in view of the aforesaid, all assessment will now be subject to the faceless assessment procedure, except relating to the international taxation, and assessment are required to be dealt by the central circuit. He emphasized that the Central Board of Directors has issued circular to decide the type of cases and how to deal with the central circle. He stated that usually cases from the income tax raid or the search has been carried out and dealt with the central circle. So the main contention of the Arvind Datar was that the case should not have been transferred to the central circle. I feel that he was not stressing the power under section 127, but his main focus was that 127 is okay, but 127 should not lead to the transfer of the cases to the central circle, because Mr. Datar was under the impression that the central circle is qua the only international tax and the search and seizure matter. Since the SSC case is not the international tax and search and seizure matter, therefore this matter should not be transferred to the central circle, and therefore the whole argument was there. Subsequent, there was another issue was there when during the faceless assessment here, if the commissioner of the first case as NFSC has the opinion that this case has to be transferred to the JAO, that is JAO, then the approval by the CBDT is required. Board approval is required. There was a bit of argument that they were arguing the issue of the 127. However, they were arguing another part here that the CBT approval is not required. The CBT approval has not been taken care. I would like to clear that CBT clearance was only required when during the phases assessment, the case is being transferred from the NFSC to the JAO, not under the 127. So the CBT approval is required for the procedure under 143(3) itself here, not the 127 here. And for this purpose, they have relied upon. Can we come to the para number 1816 here? 15, para 15, yes, 15. Yes, 15. Yes. He further submitted that. What he submits that he further submitted that even assuming there is a power to transfer. So he was more of the bit that yes, there is a 127 power is there. 127 has been challenged by Aam Aadmi Party here mainly. He further submit that even assuming that there is a power of transfer, the transfer to the central circle can only on the basis of circulars. He contended that in none of the petition those conditions are satisfied. Therefore, according to him, even if the case is transferred to the judicial assessing officer, they cannot further be transferred to the central circuit. What he is trying to argue that under the faceless assessment here, once the assessment is start here, once the national facet and the file is with the assessment here, then if the PCIT of the NFSC is of the opinion that the case has to be transferred from the NFSC to the JAO, then he has to take the approval of the CBDT. However, if the one PCIT is transferring the case to the another AO of the one PCIT who is sitting over the AO and exercising the power under 127, he is transferring the case to the another AO of a different PCIT. In that situation, the approval of the CBDT was not required here. However, the argument of the SSC was that since it is the first transfer from the NFSC to the JAO, then it is transferred to the different assessing officer central circle. Therefore, the CBDT permission is required. And therefore, the main argument of the SSC petitioner was that the permission of the CBDT has not been taken. Now coming to the para number 27, which is about the revenue argument. We have seen that what is the main argument of the SSC is there. We will discuss about the one of the important judgment, which is the Kasiram Agrawala judgment. And this argument of the revenue is worth reading here because that gives a lot of understanding of the development of the assessment procedure, how the assessment procedure has discussed here. Para number 27 talks about that what the SG has argued that learned Solicitor General submitted that the impugned order transferred the case from the exemption circle to the trust, a special circle, exemption circle in case of trust to the Assistant Commissioner, Central Circle, and both the officers are indisputably within the same city. The first part is that if it is in the same city, namely in about a 3 kilometer distance only under different PCIT, he stated that the region mentioned in the impugned order is better coordination. So what was the order 127 was passed? It was passed for the purpose of better coordination, effective management, and meaningful assessment, which reflect the administrative convenience and exigency that is the need of the assessment taking place under the same assessing officer and the future possibility of conflicting view treatment in similar transaction is averted. So the main purpose of the why the assessment order under 127 was passed for the better coordination, effective investigation, and the meaningful assessment. These three terms has been come in different under the by the different high court, and they have discussed this term here. He submitted that the project is squarely covered under the case of the Kashiram Agrawal case. Kashiram Agrawal case was that here the Supreme Court has stated what is the scheme of the 127, whether the 127 is a quasi-judicial proceeding or it is a administrative proceeding. If it is an administrative proceeding, there is no need to give any hearing to the SSC. There is no need to give any opportunity to the SSC. There is no need to pass a speaking order, or if this order should be challenged here. Then the issue is that whether the 127 can be challenged or not. We will see that what is the scope of the 127, and we will see that whether the recently the Supreme Court, there was some Supreme Court decision which talks about even the administrative order should comply with the natural justice or the Article 14, Article 21. So if even the administrative order should comply the essence of the Article 21, so we will see how the Supreme Court is in the case of Kasim Agrawal says that 127 is merely an administrative procedure, no need of giving any opportunity to the petitioner, to the SSC here. Now, coming to the paragraph number 28, he submits that the present case is squarely covered under the constitution bench judgment here. It is a constitution bench judgment by the Supreme Court in the Kashiram Agrawala, where the Supreme Court has held neither is there any requirement, very much important part that is there, neither is there requirement for recording the region under section 127 of the Act, nor any requirement of a regional opportunity to be given to the SSC when the transfer is in the same city, locality, or place. So it talks about when it is within the same city, locality, or place, no need to record any region. The 127 can be exercised without any giving opportunity to this one. Paragraph number 29, and after 29, it says that without prejudice to the he relied upon the judgment of Kamlesh Rajnikant Shah and the other order or the other Supreme Court judgment. What is this one here? It says that exercise of the power under section 127, very much important. Very much important. It says that exercise of the power under 127 of the Act is merely a administrative order. It talks about that it is merely a administrative power. Please mute them. There are many noise which is coming here. May I request all to please mute themselves here. So after this, in the paragraph number 29, he has discussed that there are many order. The 127 is an administrative order, no need of giving an opportunity. So paragraph number 29, there are Gujarat High Court judgment which talks about that it is settled that the power under 127 of the Act is mere administrative power. And based upon the administrative agencies of the tax assessment and tax collection, and does not adversely affect the SSC as its right of fair assessment under the law fair assessment under the law remains intact. So the 127 he is talking about the administrative process here. And there are various judgment on this point here that what is the administrative process and the quasi-judicial order here. Paragraph number 28. Paragraph number 30 talks about that the transfer under section 127 cannot be linked with the quasi-judicial power. Hence, even the briefest of the region and decisional public interest would be sufficient to exercise the power of the power, and the court would not interfere and such exercise of the power. Very much important. It says that it is a totally administrative issue. The court should refrain from indulging into this part. This is not a quasi-judicial order. So the intervention of the court or interference or the interference of the court should be not be there, or minimal should be there, because it is not a quasi-judicial order here. It is a purely administrative order, which is for the purpose of the tax collection and with the power of the keeping the whole assessment procedure intact here. So there cannot be case where the SSC can be said that they have been deprived of any of the rights which they have. And para number 31 also is also there. Supreme Court, the Delhi High Court also talks about the difference between the 127. And after that, there are many orders which is there. They have discussed the power of the. Now we will come to the para number 37. Whether the SSC has the vested right to go for the faceless or not here, we will see this part. The petitioner claimed to have a vested right for a faceless assessment is a fallacious. It says that as there is no challenge led to the statutory notification empowering the board to apply for the faceless assessment scheme in respect of the certain class or cases and exclude certain other cases in size of such power contained in the clause 3 of the notification dated September 12, 2019, the board has decided to exclude the international tax cases from the faceless assessment. There is no challenge here. So the court is saying that they have not challenged that why there's only the international tax cases and the such cases should go for the central circuit or the without the faceless. So therefore, the contention of the SSC is fallacious. Now coming to the para number 42. We have briefly discussed what has been happening, and now the court is being worked. Para number 42, just down the court is starting here, the order part starts from here, and the court, let's see what is the court is ruling into this part, para number 42. Having heard the counsel of the party, this court of the view that the present case involved interpretation of the notification dated September 12, 2019, August 30, 2019, and not the 144B. We know that under 144B, faceless assessment scheme is there. So this issue is for the period when the faceless assessment under 144B was not into the statute here. It is the faceless assessment was through the notification. So the challenge was through the notification dated September 12, 2019 and August 13, 2020. This means notification number 61 of the 2019, and we will see that 62 in the notification number 61 of 2020 also. As at the time of passing the impugned order, January 8, 2021, this one here, the faceless assessment scheme was governed by the notification under 143(3)(a) and 3(p). Now, what is the order here? It is pertinent to mention that the faceless assessment scheme was incorporated in the Act by the taxation and other law with effect from 1st April 2020. Consequently, the court is of the view that it is necessary to examine the scope, ambit, and interpretation of the section 127 and whether the view of the two notifications dated this one. So the court is trying to examine section 127 vis-a-vis interplay of the faceless assessment center. First, the court is going to examine the section 127. Shall we go to the section 127 here? It talks about the para number 44 is important. What the para 44 talks about? And the Kasirama Agarwala judgment, which is the landmark judgment because it was constitutional bench judgment. Kasirama Agarwala was reported in the 56 ITR 14. In the Kasirama Agarwala, it was held that the has authoritatively interpreted as well as the outline, the scope and ambit of section 127. The Supreme Court has held that the transfer order under section 127 of the Act is a mere administrative order invariably made on the ground of administrative convenience. Neither is there any requirement of recording of region under section 127, nor the requirement of reasonable opportunity to be given to the SSC when the transfer is within the same city, like Delhi here in this case, and like the present the relevant provision. So Kasi Magwala says that it is a purely administrative facility, no need to give any opportunity to this part here. Now come to the para number 45. So para number 45, the court has cleared here. Almost all the High Court has held that transfer under 127 of the Act for the purpose of coordinated investigation is sufficient reason for passing such administrative order. Consequently, it is settled law that the transfer order 127 does not affect any fundamental or legal right of the SSC, and the court ordinarily refrain from interfering on the exercise of this power. So, court has cleared that 127 it is administrative issue. I will not interfere. Now come to the para 140, para 46. Para 46 talks about the central circle. Can we go to the para 46 here? Naman? Yes. What is the scope of the central circle? So we have three parts here. First is the 127. We have seen that it is the administrative part. Then we will go to the central circle, and the most important part that then we will go to the interplay of the 127 vis-a-vis 143, both the notification issued under the section 143, whether the notification anyway negate the power under 127 of the AO or not. So we have come to understand that 127 is the administrative power, no need to give the opportunity to the SSC. However, we will see that whether 143 in any way negates the power under 127 or 127 stand alone still is independent, no need to be read with the 143. 143 has to be read separately. There is no connection between the 127 and 143. 147 has to be operate on a different context. 143 has to be different context, and the 140 and if the 143 is in a different context, the first e-assessment scheme and the first assessment scheme is also in the different concept here. Can we go to the next judgment here? Oh, sorry. So further, para on the issued by the CBDT, and the CBDT had the relevant portion of the circular was that para 46 we are there. The matter has been considered by the board, and it is clarified that the transfer centralization of the cases is done as per the provision of section 127, which is not limited to the transfer centralization of the only search cases. So para number 46 is there that it is not only the search cases will go to the central circle. The above mentioned guidelines do not deal with the centralization of the transfer of non-search cases under section 127 and not intended to preclude the centralization of the nursing. Second, third, while it is neither feasible nor desirable to draw a exhaustive line of category of the non-search cases, which may also be centralized, cases falling under the category only administrative could be considered for this. So the answer is that non-search cases connected with the search cases where finding of the search have been material bearing on the needs of coordinated investigation interest of revenue require such cases to be assessed by central circle here. So that there's a circular which says that the CVT circular says that the central circle is not confined with the only search matter. They can go beyond the search matter, primarily search matter, but does not mean only search matters here. Now coming to the para 47. Para 47, the question is that just go above the para 47. The question is having framed. Naman, yes. Para 47, just yes. the question is that whether power under 127 in any way is tampered or negated by the true notification which is there on the September, this is the September 12 notification and the September 20 notification. So issue is rising here whether these two notifications can negate the power under 127. As a common sense, we can understand that notification will come in the lower pedestal, the 127 will be coming under the higher pedestal. If there is a conflict between 127 and if there is a conflict between 127 and the notification, the 127 will prevail because it is a part of the statute, not and the 120 and the scheme is there. The scheme is a notification. The scheme will come to that lower pedestal. So the first understanding that it can first of all that is there any conflict? If there is a conflict, who will supersede here, 127 or the notifications? The answer will be there. Whether there is a conflict, we will understand whether the conflict or not. And if it is a conflict, whether it is a natural that section 127 will supersede and not the notifications here. So let the section 127 here. This court is reading the crucial para number 48 here. The court is of the view that though in the year 2019, the concept of e-assessment and in 2020, the concept of face assessment were introduced. The judicial assessing officer continues to exercise concurrent jurisdiction with the faceless assessing officer. First time the court talks about there is a concurrent jurisdiction, means there is a JO and the National Faceless Assessment Center. So we will see the interplay between the JO and the National Faceless Assessment Center. In fact, pursuant to the exercise of the power under section 120, subsection 5 of the Act, which empowered the Central Board of Directors to confer concurrent jurisdiction on two or more assessing officers for proper management of the work, the CUT Direct Assess by notification number 64 of 2020, dated 13 August 2020, conferred upon the Income Tax Authority of a National Faceless Assessment Center to exercise the power and function of assessment concurrently, very much important, concurrently, while the original jurisdiction continues with the judicial assessing officer. So the original jurisdiction continues with the judicial officer. There is another assessing officer is there through the NFAC, and both are concurrent jurisdiction. We always face the problem, can we get the notices from the two assessing officers? Like when our assessment starts here, 148 being like what happens in the 148? 148 starts from the ward here, or 148B starts from the ward here. We have to reply to the ward here, 140C, and 148D is to pass by that ward or the ITO here. And after that, 148 has been issued. This case is being transferred to the National Faceless Assessment Center, and all the return that takes place under that part that goes to the National Faceless Assessment Center. And we will see that once the 148 notice comes here, we file the ITR, then the 143-2 notice and the 142-1 notice come from the assessment unit, not from the JO. So that work has been divided between both of them, JO and the National Faceless Assessment Center here. And the court is discussing that para here. And so there is a discussion that whether there can be a concurrent jurisdiction. So we are reading that para. Conferred upon the Income Tax Authority of National E-Assessment Center to exercise the power and function of the assessment concurrently, while the original jurisdiction continues with the judicial assessing officer. The relevant portion of the notification is as follows. What is the relevant portion? It is very much important to read. In pursuance of the power conferred under subsection 1, 2 and subsection 1, 2 and 5 of 120 of the Income Tax Act, hereinafter refer to the Act, Central Board of Directors hereby direct that the income tax authorities of the National E-Assessment Center, referred to as the NEAC, specified in column 2 of the schedule below, having its headquarters at the place mentioned in column 3, of the state shall exercise the power and function of the assessing officer concurrently, very much important, concurrently to facilitate and distinct function of the face assessment. So the law itself says that there can be more than one assessing officer. Can be more than one. So one is the JO and one is the dispatcher. So therefore, when there is both more than one assessing officer, what is the function which has been divided here? So para number 49 is there. It is clarified that e-assessment and faces a scheme that once the case is selected for the scrutiny, for a limited purpose of passing assessment order for a particular assessment year, the case is assigned to the NFAC, and after the assessment, electronic record of the case are to be transferred back to the judicial assessing officer. Further, e-assessment scheme and the faces assessment scheme under the 143(a) and 3(b) of the Act clearly stipulate that the provision of 127 shall apply, subject to exception, modification, and adaptation as stipulated therein. In other words, if the faces assessment scheme is not modified, in other words, if the faces assessment scheme has not modified section 127 of the Act, the power under the said section would continue to apply in all cases in an unmodified manner. So it says that the power under 127 will apply here. Now, coming to the pad number 52. It says that because of the pad number 51, can we go to the pad number 51 also? Because clause number 21 is there in the pad number 51. Under the clause number 21 of the notification, that is 61, that is of 2019, of the Act, order of the give effect of the e-assessment scheme, the National Assessment Center to transfer the case of the SSC at any stage of the assessment, only when the assessing proceeding is pending before the National Assessment Center to the assessing officer having jurisdiction over such cases as the scope of power of function of the NFAC is limited to facilitating the conduct of the cases. So, para number 52, consider this court of the view that the two notifications dated 19 enlarge and supplement the power of transfer by authorizing the NFAC to transfer at any stage of the assessment in the case of SSC to the assessing officer having jurisdiction over such cases from the face assessment center to the judicial assessing officer. So they are discussing about the power under this part here. Let's come to the where the SSC objection is there, whether the approval is required. We will go to the pad number 56. The above mentioned subclause in the notification dated this one's here. This one transfer the made refer to the transfer made from the National E-Assessment Center at any stage of the assessment, that is during the process of assessment alone, where any transfer order under 127 of the Act, whereas any transfer under 127 of the Act changes the assessing officer having jurisdiction over such cases from one officer to another officer, even when there is no pending proceeding. So here the court is discussing the proceeding under 127 and 143 is a different proceeding. 127, under the 127, the case can be transferred from one assessing officer to the another assessing officer, even though no assessment is pending. However, in the case of the NFAC can transfer to the JO only when the permission of the CBT will require, only when there is a pending assessment is pending. So the difference between both the transfer is that first transfer is under the 143(3)(a). Under the 143(3)(a), the NFAC commissioner NFAC transfer to the JO only in a situation first the assessment is pending. The second, this transfer required the CBT approval. Whereas under section 127, the transferor can transfer to the case to the SSC to the transferee, even though there is no assessment is pending, no case that assessment is pending before the transfer case. So there is no requirement of the under 120. So 127 operate in a different context, and the one approval under the scheme operate under different escape here. So para number 57, the contents of the petitioner that the requirement of prior approval of the CBDT as stipulated in this one here has been violated is untenable, as the transfer in the present notification fall under 127 and not under such notification. So very much important. The transfer under one notification is something different. 127 is different. Transfer under notification is different, and therefore both are separate part. It cannot be 127 has not been negated. Para number 58. Consequently, the transfer of cases under 127 of the Act is altogether different power which continues to exist even after the introduction of the e-assessment of faceless scheme. Very much important. He say that the power under 127 of the Act is altogether different, which continues to exist even after introduction of the e-assessment of faceless scheme. Accordingly, the said scheme does not in any manner trammel upon or negate the existing power contained in section 127 of the Act to transfer the case as provided for thereunder. Consequently, the power of transfer under 127 of the Act is not in any manner denuded by the National Faceless Assessment Scheme when the transfer is sought to be made from the jurisdictional assessing officer under one principal commissioner to the income tax officer under different principal commissioner, different commissioner of income tax who are not exercising the current jurisdiction power that is here. So the court is very much clear that 127 is a different part here, and and the transfer under this scheme is totally different scheme here. After that, the court has gone into the other part is also there, mainly is that the grievances of the petitioner that there should be approval is required. The court has clearly said that no approval is required. 127 power is intact. 127 is a administrative process. Kasiram Agarwala has to be relied. Supreme Court judgment. It is an administrative process. No need to go for any objection that has to be given, or any natural justice has to be given, any opportunity has to be given. No need of that part here. Coming to the central circle, role of the central circle is not confined with only with the search cases. It can take up the other cases also as per the expediency of the matter. And the third part is that 127 as well as the notification part, there is no conflict between two. 127 intact. 127 power is totally intact. It is an independent power. It is not vitiated by the notification. Notification is qua the transfer by the NFAC to the another assessing officer under the JO, where the assessment is pending. However, under section 127, there is no need to assessment is being pending. There is nothing like this one here. So the 127 exists independently here. So therefore, there is no need of getting the approval of the CBDT. Board approval is not required. And after that, there is another issue that is there. There is a discussion on the 143. And can we go to the para number 60? Yes. Para number 60 talks about whether the SSC has a fundamental right to go for the faceless assessment. The court says, no. This is not a vested right, because the para number 60 talks about the court is of the opinion that the no SSC has any fundamental or vested legal right to be assessed by the faceless assessing officer by virtue of the amendment in the 143(3)(a) and 3(b). Firstly, section 143(3)(a) of the Act stipulates that the CBDT may make a scheme to eliminate the interface between the AO and SSC. This implies the central government has the discretion to frame and not to frame the assessment, national facility assessment scheme. Consequently, the argument of the face assessment vested right fails to consider the language of the statute itself. So the law is telling that no, that is not a vested right. So with this conclusion, the court has dismissed the writ of the petitioner here. Now this matter is pending before the Supreme Court. As I know that this matter is coming before the Supreme Court in the first week of August here. There was no stay also. The court has only issued the notice to the CBDT, notice to the department here. So there is no stay on this part here. With this, we have come to a conclusion of the first judgment. I know that it has taken a bit long time here, but this was very much interesting to know the interplay of the different legal intricacies here under that part here. Yes, can we go to the next judgment here?
Sir, what is the ITR number?
ITR number is 198. After that, it will not be take time more here.
So 192.
198.
Yes.
This is one of the important judgment from the Calcutta High Court. There are two issues that when the business expenditure has to be allowed here, whether the business expenditure has to be allowed at the time of accrual or at the time when the amount is crystallized here. We know that unless the amount is crystallized here, there may be, we create provision here. The provision may be with the previous year or like we have created the provision here. But this provision will, if the provision is being crystallized in the year of the in the previous year, can it be said that this expenditure was related to the earlier year, so it is a prior year expenses, so it will not be allowed here. The court has said that the year of allowances will be the year when the amount get crystallized here. So and it has been done as per the accounting practice followed by the SSC, as per the accounting standards of the ICI, and in terms of section 145, since it has been consistently followed by the SSC, and it has been verified by the CIT appeal and the ITT. Therefore, the court has rejected the revenue appeal, saying that this is as per the accounting, and there is no case of the prior period. The claim has been given in the year when the deduction has been, when the amount has been crystallized here. The second part is that is more interesting here. The SSC has invested certain amount into its subsidiary. However, the subsidiary has come into the loss, and the subsidiary has opted for the corporate debt restructuring, and under the corporate debt restructuring scheme, RBI has interfered and said that SSC should convert the loan into the preference share. Once the loans has been converted into the preference share, there is a loss of net worth of the subsidiary company, and therefore, since there is a loss of the net worth of the company, the SSC has written off such loss, and once SSC has written off such investment, and when such investment has been written off, the SSC has claimed the deduction under section 37. If the SSC has claimed the deduction under section 37, whether it can be disallowed or not here. So the first point was about when there is a liability, it is not the incurring of the expenses. When there is a liability, when the amount is crystallized, then that is the year the deduction will be allowed under section 36, 37, 32, and under section 37. And the second part is that if the investment has been made and the investment has been converted as per the CDR scheme, where the RBI has asked to convert this as a preference share, and subsequently there is a loss of the net worth of the subsidiary company, and it has been allowed, then in that situation, the can we claim the deduction under section 37? It looks like that the court has stated that it is a revenue expenditure, and if it is a revenue expenditure, this can be, the deduction can be claimed by the SSC. Very much important. This is a April 23rd, 13 appeal judgment here. It gives a very clear thought here, because we know that many Indian companies have invested in the subsidiary company outside India. And we have seen that many subsidiary company has become liquidated here. If under that situation, if the company is liquidated, can the SSC claim the loss of investment as the deduction under section 37? If we go through this provision here, it looks like that there can be some chances of claiming the in deduction against the business as a business expenditure. However, what is the crux here? The crux that we have to see that whether this investment was for the purpose of earning the dividend, or whether this investment was for the purpose of SSC own business here. If it was for the SSC own business and it was getting the interest can only be given when it was a loan here. And if the interest has been considered as the income from the business and profession, then there is a better chances here. But if the investment, if the take a case that SSC has invested in the subsidiary company outside India, thus that subsidiary company has become liquidated, whether there can be some write-off of the investment. If we go through this judgment, we find out that yes, there can be some scope of the write-off of the such judgment here. So these are the two broad issues which has been discussed in the case of the Balmain Lorry and Company Limited. And I'm coming straight to the issues where we have discussed this para here. Can we come to the para 6? Para 6 is it? Can we come down? There is a discussion on the Batidas Daga case here. Please come down. Yes. Just go up. Go up. I'm reading from here. Thus, the SSC contended that the sum of rupees 11.82 crore is allowable both in the normal computation as well as the computing book profit under 115 JB of the Act. The Commissioner Income Tax Appeal, after considering the above factual detail, pointed out that the SSC case revolves around the fact out of the loan of rupees 13 crore advanced for the purpose of the business, rupees 11.82 crore has turned bad, and though investment was initially propelled by the business expediency and was subsequently thrust on the SSC by reason of the RBI, the corporate debt restructuring here that we discussed here of the this one here, taking note of the factual position and the following the decision of the BGR Bank here. The SSC has been allowed the decision of the BGR Bank here. The SSC appeal was allowed and the disallowances of rupees 11.82 crore was directed to be deleted by the assessing officer here. The department view is that these are the expenditure. This investment was turned bad by way of the turned bad, and after that there was a corporate debt restructuring which has taken place in the case of the company. And since the corporate debt restructuring taken place, the SSC was go for the purpose of the preference share, and this preference share has lost its value. Therefore, this amount should be considered as a business loss, and that part here. Para number 7, come to para number 7 here. Yes. The learned tribunal, after considering the aforementioned decision, found that the fact of the SSC case was more or less similar. Since the transferee was a subsidiary promoted for furtherance of the SSC freight container business and furtherance of the such business, loan were advanced from which the interest income was earned, and such interest was assessed under the head business. Very much important. The interest income was taxed under the head business. Further under compelling circumstances and as per the direction of RBI, the loans were converted into the preference share, which consequently eroded its value because of the loss sustained by the subsidiary. Therefore, the tribunal held that merely because the loss was debited under the nomenclature provision did not alter the basic character of the transactions, and the loss incurred due to non-recoverability of the amount advanced in the ordinary course of the business could not be disallowed by the AO. With regard to the objection raised by the revenue, the relief granted by the Commissioner of Income Tax appeal, while computation of book profit under 115 JB, the tribunal rejected such objection raised by the revenue and rightly placing the reliance of the decision in the case of Gujarat torrent cases. Gujarat torrent was on the issue of the 115 GB that such losses should be deducted for the purpose of computing the book profit, and therefore that was allowed here. Based on this part here, based on this, relying upon this factual finding by both the two concurrent factual finding by the CIT appeal as well as the ITR, the court was of the view that there was no need of interference. So in that view, the section 260A appeal of the SSC or of the department was dismissed here. Can we go to the another judgment? That is the GC Material Private Limited, 455 ITR 211. Yes. This judgment is also interesting here. It says that when an SSC can claim the refund, there is a notification which was issued here. And this notification was issued in terms of this, and this is a circular 9 of 2015, very much important circular, which gives the where to claim the refund, and if that refund has to be claimed within the period of 6 years itself here, and if the period of 6 years the refund has not been claimed within the period of 6 years, what will happen here? There is an important judgment on this point here, and we should understand that in many cases we have seen that SSC has not claimed the refund, or if the SSC has not claimed the refund, what will happen? How long they can keep on pending here? And where to claim the refund. So this question is mainly on the circular number 9/2015, and the circular number 9/2015 we will discuss here in detail here. What is the circular number 9/2015 and whether any limitation can be provided in the circular number 9/2015 or not here, and we will see that part here. Let's come to the. It is mainly on the limitation on the circular number 9/2015. The fact of the case is that SSC was an AOP. However, the PAN number was issued. The PAN number was issued for a company, so that the credit of the 26, the credit of the TDS was not reflected in the PAN of the SSC. When the SSC further requested to change the credit to the AOP here, then the PAN started, then the credit started reflecting here. Then the issue is that when you should claim the refund here. Come to the PAN number 3. This is a small judgment, so we can go fast here. Very much relevant for us. PAN number 3. The petitioner further states that the petitioner requested for the cancellation of the old PAN since the petitioner has obtained a new permanent account number as an association of person. It appears that thereafter there was a complete lull on the part of the petitioner, and the petitioner woke up only in year 2020 and sought to take action for reflection of the tax deducted at source of rupees 14.61 lakh against the new permanent account number obtained for the petition in 2008 itself. The petition states that the income tax authority have also reflected the aforesaid tax deducted at source against the amount against source amount against the new permanent account number of the petitioner as an association of person. The petitioner then applies for the rectification of the assessment order. Very much important. See, the petitioner has applied for the rectification of assessment order under section 143A of the Income Tax Act. So let's see that 143A of the Income Tax Act. What is the power under 143A? Very much important is so that when we should claim for the refund. As of now, there is no section of 143. 143A has already been deleted in the section here. Just hold on. 143 is there. Sorry. There is no section called 143, but let's see, still the circular is there. However, the said application has not been entertained on the ground that the application for rectification has been filed beyond a period of limitation and even beyond the period on which the application for continuation of delay could be entertained, which was 6 years from the end of the assessment year for which the application claim is made. The order dated February 2020 passed by the respondent. So what the respondent under the past and order when they have claimed for this one, the SSC has submitted that the SSC has submitted application for July 9, 2021 for granting permission under section 119 of the Income Tax Act for the assessment year 2008-19 for the claiming of refund. So the special section of 119 has been invoked in order to get the refund for 2008 and 9. And what the department is saying is rejecting the claim. The department is saying that in this regard, it is to state that as per circular number 9 of 2015 of the CBDT, new CL number 3, no condonation application for claim of refund loss to be entertained beyond 6 years from the end of the assessment year for which the application claim is made. So we have an upper limit of 6 years. The application for the SSC is not covered in the aforesaid central. Therefore, the application for the SSC is not covered by the aforesaid CPT circular beyond 6 years from the end of the assessment year for which the assessment has been filed. Since the petitioner was not covered under the circular number 9/2005, and that came to the stumbling block by the petitioner seeking continuation of delay beyond the period of 6 years from the end of the assessment year pertaining to the application claim was made. The petitioner has assailed the said circular as well. So the circular has been challenged before the High Court here. And the circular, what is the relevant portion of the circular is that in the para number 4. Naman, can we go to the para number 4? Yes. Para number 4 talks about no condonation of application for claim of refund loss shall be entertained beyond 6 years from the end of the assessment year for which the application is made. This limit of 6 years shall be applicable to all authorities, except having power to condone the delay as well as the above prescribed monetary limit, including the board. The condonation application should be disposed within a period of 6 months from the end of the month in which the application is received here. So the maximum time period was given for the 6 years. This application was beyond the 6 years. So therefore, the court has come to the para number 8, para number 9. Come to the para number 8 itself. The court has upheld the circular validity. It says that when section 119 B of the income 2B of the income tax authorizes the board to issue no instruction, direction order to the income tax authority to admit an application or claim of any exemption, deduction, refund, or any other relief under this act after the expiry of period of limitation specified by this act, along with the said power goes to the power to prescribe the condition upon which such delayed application may be entertained. Since the petitioner sought continuation of delay by resort to very same circular number 9 of 2001, the petitioner has to accept the condition prescribed in the said circular for entertainment of application seeking the continuation delay. Therefore, it is not correct for the petitioner to contend that the board has no power to lay down the outer limit of the limitation during which the period of application for condonation may be entertained. So the challenge was whether the board can prescribe any limitation through the circular. The court has upheld that part here. Court saying that once the circular has been relied to, the circular itself, the board has relied the outer limit, and the outer limit 6 years has to be complied. Since your application for the refund was after 6 years here, and there cannot be any delay there cannot be any condonation of delay in this regard here, as per the circular here. So the court has said that, and therefore the court has dismissed the writ of the SSC here. After this, we will go to the Supreme Court judgment, and the Supreme Court judgment is for the purpose of, there are two judgments of the Supreme Court judgment. Is the international tax, this one is the CIT international tax and IGM corporation, and the second one is the ITO versus Tapan Kumar Ghadi. So can we go to the page number 357. One judgment which is there on the Mr. Tapan Kumar Khadi is for by the department. Department has quashed the assessment order. It was from the Orissa and quashed assessment order, and where the High Court has quashed assessment order, saying that it is beyond the limitation after the expiry of relevant assessment year on a petition special level this month here. The court simply stated by going through this one here. The court has dismissed the SLP of the revenue. However, the question of law of the limitation, which is pending before the Supreme Court in many matters, like Rajiv Bansal cases, like another matter which is there, Kinara case is there pending before the Supreme Court. The Supreme Court has kept the question open here. However, the SLP was dismissed here. Now coming to the IGM Corporation. IGM Corporation by the Supreme Court, we will go through the IGM Corporation and let's see what was the issue before the IGM Corporation head. And it was from the judgment from the Madhya Pradesh High Court, which has traveled to the Supreme Court here, and in the MP High Court, whatever the MP High Court has decided, this was the issue of the TDS here. Let's go through the brief fact here. The fact of the case is that IGM was a contractor who was working in Madhya Pradesh and it was suffering the loss here. He has applied for the no loss, no TDS has to be deducted. Since there was no income that was arising to the SSC, the deductor has not deducted tax here. Subsequently, the department has made the deductor as the SSC in default, and after that the tax was recovered from the deductor here. The issue was there when the SSC was not liable to tax here. Under that situation, whether the deductor should still deduct the tax, or can he say that since the SSC is suffering loss here, there is no income per se, so therefore no TDS has to be deducted. The High Court has passed the order saying that this amount should be refunded to the deductor and there should not be any recovery from the deductor, because the SSC was assessed at the loss figure, and therefore there cannot be any requirement to pay tax on its income, and therefore there cannot be any SSC in default. And under that situation, the interest recovered under section 201 also was illegally retained by the department, and that he was asked to refund that amount here. When this matter has come before the Supreme Court has not interfered into these issues. And let's see, when the Supreme Court has not interfered in this issue, what was the main implication was there here. I'm coming to that directly on the issue of the legal party there. Para number 11. We have a learned counsel. We have heard the learned counsel of the party at length and find that the present petition deserves to be allowed. Why? We proceed to examine the scope of relevant statutory provision. Section 195 of the Act is a special provision for the tax deduction at source and payment to non-resident. All payment escape under the head salary are covered thereunder. The explanation appended to it makes it clear that even to the credit of the non-resident or suspense account is tantamount to the payment for the purpose of the tax deduction source. The relevant provision of the 195 is there. And after that, there is a discussion on the 197, the certificate part is there. Can come down. After that, please come down here. Para number 12. Para number 12 is important here to read this part. The cumulative reading of the aforesaid provision, we have read the 195, 197, 201, and 191 also. The cumulative reading of the aforesaid provision leads to the conclusion that where there is no tax liability on the recipient of the income in respect of the entire income, including the income paid on the deductor, then in that eventuality, no liability can be fastened on the deductor under the section 201 of the Act in respect of payment made to the deductor. So it says that in the case of when the assessee is not liable to pay tax, so there cannot be any liability which can be fastened on the deductor that you should be still deduct that tax. Once it is held that no liability arises against the deductor under 201 of the Act, when the deductee has been assessed at loss figure, there is no justification for levy of interest under 201A of the Act, as the same is consequential in nature. In other words, in the situation where the deductee is not required to pay any tax and his income, there is no reason to hold that the deductor is in default under 201 and 201 of the Act, as deductee is not required to pay any tax on its income, which is in fact is a loss. Very much, para number 12 is very much clear that count is that if the assessee is not liable to pay the tax and he is suffering because there is no income and he is working at loss, since he is not liable to pay the tax under section 195, there is no income that is getting with the assessee. So there is no case that the deductor should deduct the TDS. If there is no liability to deduct the TDS here, so where the issue of the interest that will be arise for non-deduction of the tax, the interest is consequential of non-deduction of tax only in a situation when the deductor or when the payer was liable to deduct the tax. When the payer itself was not liable to deduct the tax, there is no case of the interest which can be asked by the assessee by the deductor, and therefore that interest itself is not liable, and therefore it says that that interest should be refunded here. Can we go to the para number 15? Yes. Still further, respondent number 1, while passing the impugned order dated this one, has assigned the region that the default was deducted in the case of NHI, respondent number 3, which was assessee over the respondent number 1, exercise jurisdiction. The NHI was liable to deduct and deposit the tax at source and interest for delay, but the NHI, instead of paying it out of its own coffers, illegally recovered the amount from the IJMC petition. The charge of interest was created on the NHI and not on the petition, and therefore the claim of the petitioner was not justifiable. In view of the aforesaid elaborate discussion, in our opinion, the region assigned by the revenue, very much important. In view of the aforesaid elaborate discussion, in our opinion, the region assigned by the revenue to decline refund of the interest under section 201 of the Act recovered from the respondent 3 NHI on behalf of the petition is untenable as after detailed scrutiny, respondent number 2 found that the petitioner was assessed at loss and therefore allowed the tax deducted at source paid in his favor. The tax deducted at source was refunded to the petitioner in accordance with the law. Then in the situation, no interest recovered from the respondent number 3 under section 201 of the Act could be legally retained by the revenue. So the issue is that when the whole of the tax was refunded to the foreign company, saying that it was a loss one here. So can the interest be interest which was paid by the deductor can be retained by the department? The court is coming into that part and saying that then in that situation, no interest recovered from the respondent number 3 under section 201 could be legally retained by the revenue. In this section, interest under section 201A of the Act deducted and deposited by the respondent number 3 with the office of the Assistant Commissioner of Income Tax applicable to all to have been refunded. Very much important discussion. Therefore, on the fact and circumstances of the present case, any payment of tax deducted at source by the deductor in respect of payment made to the deducting person will entirely be deduction to get back the such tax deducted at source with the interest at the time of claiming the assessment under section 143 of the. In such eventuality, it was not proper to hold the deductor as SSC in default under section 201, nor interest could be levied under section 201 of the Act. So it says that there cannot be any interest which can be levied under that part here. We have time. We will cover one more judgment, 1 and 2 more judgment, which is there here.
Hello.
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 Yes, sir. Namaskar.
Why not? Namaskar. Why not that Tapan Kumar little in detail, Supreme Court? We just referred it.
Yeah.
Tapan Kumar, sir. Whatever is there, we can just 5-7 minutes we can discuss. It's a live issue.
Reassessment under 148. Okay. And it was coming from the Odisha High Court, sir. Okay. And it was held that particularly that notice which was the income tax on dated March 31st has been issued beyond the period of limitation after the expiry of the relevant assessment year. Whether this limitation issue on which the limitation issue, the High Court has rejected the department plea that 148 is beyond that, is within the time here. The High Court was of the view that this notice is beyond the limitation period and therefore the was the assessment proceeding. Okay.
No, which year's notice and which was the date?
Just hold on, sir. Yeah. Just hold on. Justice Muralidhar, 452.